What?
Good morning, everyone. This is the House Discrimination Prevention Panel, and we are going to start right off with Legislative Counsel Damian Leonard walking us through some policy. And you can find the policies that we're going to be working on the website for the Discrimination Prevention Panel under today's date. And Damien, I'll leave it up to you and whichever one you want to start with, the rules of procedure or the policy itself.
Well, I'll start with the policy. That'll hopefully be the quicker of the two. Mike, could you make me a co-host and I'll throw it up on the screen, or would you just prefer that I walk you through it verbally?
Oh, there we go. Sorry, David. Go ahead.
I think this on the screen would be good for
Okay.
folks that are in the room.
Great. Go. Okay. Can everybody see my screen?
Yes.
Okay, great. So what I've done, like I discussed last week, I've taken the policy and separated out from the procedures. I've highlighted points where I've made changes here. And I'll explain those as I go through. So the first change in the second paragraph here is the panel is actually called the Discrimination Prevention Panel, not the Prevention of Discrimination Panel. So I just corrected the title. I apologize for that error that's been sitting there for a couple of years now. And then the next section here, I realized looking at the House rules that the House rules only apply to representatives and staff in the House, meaning the clerk's office and the speaker's office. So because in the past we've applied it to employees of other offices working in the House, I've left it as just all staff who work for the House. But I think if you look at the House rules, the intent is that it only cover that the regulated individuals are only House members and employees of the clerk or the speaker. And that may be something that the House wants to revisit in its rules going forward. Under the sexual harassment prevention policy, the staff of the nonpartisan offices like Legislative Counsel, Joint Fiscal, Leg Operations, we're all under the Joint Sexual Harassment Panel, which is composed of 3 members of the House panel and 3 members of the Senate panel. But because the Senate doesn't have its own discrimination prevention panel, I'm not actually sure what the appropriate jurisdiction is there. And the House rules seem to indicate that the intent, at least at that level, is just to govern House employees.
Damien, could you make note for us to address that with the speaker's office?
Yep.
Thanks.
The important thing to note is that all staff and members of the public and legislative pages are still able to utilize the panel if they've been discriminated against by a regulated individual. So the panel is still able to adjudicate claims made by people outside the House. It's just not clear whether you actually have the authority over, for example, me when I'm working in a House committee, if I were to, make derogatory comments or something like that, it's not clear whether this panel would have jurisdiction or whether they'd have to refer the complaint directly to my supervisor.
Okay.
So the next change is here under the definition of discrimination. It's the same definition we've been using. The only change is to switch from there to the individuals. This is part of the General Assembly's gender neutral drafting guidelines. We, instead of using they, there, because that can often be confused with a plural. So it's both singular and plural. We use the individuals or the persons or something like that, just to be clear that we're referring to a singular person rather than people in the plural. So you may see a couple of those changes throughout, and we're just doing this for consistency.
Okay.
Under workplace harassment, there are a couple substantive changes here. The first is I've added in the word written to the description of workplace harassment. So workplace harassment may be verbal, physical, auditory, and it used to say just or visual or a combination thereof. I've added written in there. Visual or physical could arguably have covered written, but I think it's important to set that out clearly, particularly in a day and age when the discrimination could be by text message or something else, or email. This, I think, is just a good clarification. In the next sentence, you'll see a lot of changes. It's just changing the tense. The editor felt that maybe personally offensive, fail to respect the rights of others, lower morale, was confusing. And it also, the word maybe seemed to be, that's sort of a ambiguous term, especially if we're just describing other forms of conduct. So I think also conduct that is personally offensive, fails to respect the others, lowers morale, interferes with work, or violates a person's sense of well-being, makes it a little bit more clear. But that is definitely a policy choice because the maybe does leave maybe a little bit more flexibility there. So you don't have to find that it was actually personally offensive, just that it could be. So that's something that's definitely worth discussing. The other thing that I've struck through here after work, I've struck through the word effectiveness. And this is another policy decision for the panel. This is something that Bor Yang highlighted to me. And the concern here is, so if you're going to interfering with work effectiveness, does that mean that an individual who is able to, just keep doing their work despite the harassment doesn't have the same right to say that they suffered workplace harassment as someone whose work suffered? So by saying interferes with work, that's a little bit different standard because, that's basically asking like, did it actually interfere with your work rather than did your work suffer and you were no longer as effective at work? Because people may, they may work after hours, they may work in a different location, all sorts of things to avoid the harassment. And so their work may not suffer, but they're still experiencing the harassment. And so that was something that she highlighted to me. And this is part of a larger discussion nationwide over how some courts have been interpreting the law. And so the question here really is, do you want to leave it as effectiveness, which would really focus it in on, is the person still able to do their work as well as they were before the harassment began? And if the answer is yes, then they may not have a workplace harassment claim under our policy. Or do you want to look at, did the harassment interfere with their work? Did the employee have to change their schedule? Were they constantly dealing with interruptions from the harassing individual? Did they have to start screening emails or calls? I mean, there could be all sorts of things here that they have to do without their work suffering. Does that make sense?
Yes.
Okay.
Is that a yes or a question?
An affirmation about it.
Okay.
In our committee, we've been working with Damien about these definitions and for workplace, for schools, and for fair housing. And I think a good example of schools is a kid can be being bullied pretty consistently and still be an A student. And so if we keep an effectiveness that kid or that employee here or us, even though we can do our work. So I think we should strike out effectiveness because it's really a separate standard. Damien, the other thing I would ask is we have with you kind of culled through in the legislative language and said harassment doesn't have, it's neither severe or pervasive. Because that is often a standard too, is like, well, it's one off, but that's, we're trying to eliminate that and clarify that. So I don't know, Damien, if you think that needs to be here.
So this policy does not use the severe or pervasive language, I don't think.
Right.
So I don't know that that needs to be here. The
a good framework for the policy to say it doesn't have to be neither severe or pervasive. For it to
yeah, so that gets to a good point about the existing case law basically says that harassment, whether it's sexual harassment or harassment on the basis of another protected characteristic, in order to be a claim that you can actually succeed on in court, you have to be able to show that the harassment was severe or pervasive. And that standard, so the issue with that standard for our policy is that if we require people to show that in order to make a claim under the policy, without getting to the sort of policy questions behind the bill that House General's been working on, is that you can have discrimination occurring, but then you could make a finding that, well, it hasn't occurred enough to be pervasive, or it hasn't occurred, it wasn't bad enough to be severe, so we're not going to find a violation of the policy. The problem with that is that we are aware of the discrimination or harassment occurring, and if it occurs again, we are now liable as an institution. So getting away from the question of even whether severe or pervasive is the right standard, and House General has been working on language that would say the right standard is did discrimination occur, not did severe or pervasive discrimination occur. But getting away from that policy question altogether, as an institution, our job is to maintain a workplace that's free from discrimination. And so if you wait for it to be severe or pervasive, then we've essentially failed to do that. So that may be language you want to add in to say that, to be a violation of this policy, discrimination and workplace harassment need not be severe or pervasive.
Yeah, that's the phrasing I was thinking.
Yeah.
About.
Can you make a note to add that? I don't think we're going to be able to go through the policy comprehensively enough this morning to come to a vote, but I think we should add that as a point of conversation. And while we're on that section, does anyone want to have a conversation about the maybe personally offensive. I am concerned about the general understanding about when conduct is offensive, who gets to determine that, and by what criteria. So does anyone have thoughts or concerns about striking maybe, or not striking maybe?
So I'm coming in late to the
Good
conversation,
morning.
Chair, good morning. One piece of the policy that I remember is that when talking about, yes, harassment in the workplace, there are some times where the person who is on the receiving end of the harassment may not perceive it that way, but that others in that space may actually perceive it to be harassment. So I think that maybe actually opens up that opportunity to have a larger discussion as to what constitutes harassment in the workplace. But I also understand your concerns of who is the one deciding at the end of the day. I think that it's a larger, complicated conversation.
It's worth noting that already in the policy, we say the victim does not have to be the person toward whom the offensive conduct is directed, but can be anyone affected by the offensive conduct. So I think I definitely hear your point, and I just want to say that I think here, if the conduct is personally offensive to the person who was affected by it, even if they're not the one who it's directed towards. So, say there was, two individuals of the same ethnic background, and one individual overheard the other individual being subjected to slurs. That individual, even if the other individual is like, I'm not offended, the first individual could be personally offended after having heard those slurs. And so to them, it is personally offensive to hear that kind of language in the State House. So again, I think the maybe adds in a little bit more discretion, particularly on the preventative end. Before someone says, I'm filing a complaint, someone says, I witnessed this in committee the other day, and I'm really concerned about this language. And that's more in the scope of, how do we head this off before this occurs with someone who is offended. And is that what you were getting at, Representative Small, or?
You said it so much more eloquently than I did, Damien. Thank you. Yes.
Okay.
So is the panel good with using a straw poll? We're not taking a formal vote right now, but keeping the language maybe.
I like no, so I would say no. I like the activation of is personally offensive, fails to, lowers morale, interferes. So if Kelly experiences some kind of harassment, I think or anyone, I'm looking at you, has a right to make a claim. And I think she claims the harassment and frames it, and the panel would have to. So I think is the right verb there for me.
And I think to Damien's point, by having maybe allows more of that nuance of the conversation, where it's, if I'm questioning if it is or is not personally offensive, can I come to the panel with it if I don't know that it is definitively, versus that may allows more open-endedness?
Yeah, I mean, there is nothing that prevents people from coming to the panel. And it's worth noting, there's nothing in this policy that prevents the panel from having a conversation with someone if they've, received some questions or complaints. but just doing it informally and saying, hey, heard about that exchange yesterday. We're sure that I think oftentimes people say things in the heat of the moment that they regret saying later. And, say, we heard about that and we're concerned about it. We just wanted to make sure it doesn't happen again because, that's getting close to something that, someone might file a complaint to us about. So there is that opportunity too. I mean, that's the kind of conversation that if you were a supervisor, you might have with your employee. And it's the kind of thing where I know certainly in my own experience, when I've used the wrong words in committee, people have sought me out afterwards to say, hey, the term you use there isn't the appropriate term. Next time, can you do better, please? And so that there is that opportunity for constructive feedback, even if it doesn't get into the complaint process. I'm probably just muddying the water here, but I think the question is, do you want it to be so maybe personally offensive versus is personally offensive is really a question of where do you want the line for it to be actionable harassment under the policy versus maybe having a preventative conversation. I think that's probably the better statement of this. And I apologize if I'm kind of been muddying the waters here this morning trying to get through this.
My concern is that if we don't use may be, that an individual may not be certain that the conduct that they experienced rises to a definitive level of offensiveness to even communicate with the panel. So to me, adding maybe allows more, I think you used the word flexibility, for individuals to understand and be supported in, we can have a conversation about whether or not this conduct would be considered offensive, and a conversation about how the panel would address that. So to me, it makes it more likely that an individual will feel supported to come to the panel.
Okay. Do you guys want to just take a straw poll? Or do you want to think on it and I can just leave it as an open question?
Leave it as an open question, I think, for now. Any other panel members have concerns, comments about this?
Okay.
Well, if someone is thinking about coming to the panel, you would think that they had been personally offended. Your own experience will have you knowing if you have been personally offended. So if it's a question of whether it's conduct between, me and someone else, or conduct that I witnessed happening between two other people, that's but the is basically says like, well, if you have felt personally offended, then that's a conversation that is worth having, and then whether it falls into the policy or not, what the outcome is part of the process. But I feel like if the maybe is a question of how one has experienced whatever the conduct is, that's maybe that's what makes it feel muddy, because people know when they feel offended at the very least, whether or not it is legally would be considered discrimination is what we're here for. So I might be swayed to think more that is it's a good word to have as a policy.
And Damien, do we, help me remember in the rest of the policy, to the question of who gets to decide what's offensive or not, do we have in the policy more definition about that?
So it,
We have a bill to get, we have to get out today. I'm sorry. Our committee's starting at 9. So
Come back to
So
it.
we'll continue the conversation, but this morning, and then we're meeting again on the 29th. And we can talk amongst ourselves.
Thank you, Damien.
In between now and
you're
then.
welcome.
Representative Kalaki.
So
luck.
the way the policy is phrased is an individual who feels they've been discriminated against or believes they've been discriminated against is the person who can bring a formal complaint. And then for the informal process, it can be an individual who thinks they've been discriminated against, or an individual who thinks that they've witnessed discrimination or has become aware of conduct that they believe is a violation of the policy, such as a supervisor whose employee came to them and said, hey, this happened to me this morning, is this appropriate? And then if the employee doesn't want to come forward, the supervisor could come forward to the panel and ask for an informal solution. So that it really depends on the victim, but then it's the panel's role to actually make a determination of whether the policy was violated. And so that's where the is or may be or may fail to, respect the other rights of others, or may be personally offensive versus is personally offensive. That's the standard that you as a panel would be applying. So it's up to you as a panel to make that determination. And you'll make that determination based on the facts and the circumstances of each particular claim.
So is maybe necessary because of the ability for a third party or a witness or a supervisor to be the one filing a complaint? Is that the?
It still is, so the supervisor or a witness could still say, that, that's offensive behavior, or that's inappropriate behavior. That behavior fails to respect the rights of others, it interferes with work, whatever it is, and bring it to the panel and say, I think this is a violation of the policy. And then the panel, just like in court, the panel makes a determination based on the facts after they gather information. They say, yes, we agree, this is something that was personally offensive or fails to respect the rights of others, or interferes with work or any of the other standards. It was unwelcome conduct based on a protected characteristic. Whatever that conduct might be, whether it's, using slurs, making jokes, sending harassing emails, or, in a really bad case, something much worse than that. And then the panel at that point would say, we've reviewed the facts, we've taken information, and this is what we understood happened, and we believe that this is a violation of the following standard in the policy. So that's really your role. And for other people, their role is just to say, I think that this violates that standard. So, that conduct didn't respect my rights. It violated my sense of well-being, and it lowered morale. Or for the supervisor, coming to you, my belief based on talking to my employee is that behavior lowered the employee's morale and interfered with the employee's work.
So we wouldn't be limiting the panel's ability to address this if we use the word is.
I think in either case you can address it. I think is a little bit more of a solid black line standard, although it's still subjective. It's the panel's determination of what is personally offensive or does fail to respect the rights of others, or does lower morale, or does interfere with work, or does violate a person's sense of well-being, versus, well, this might violate a person's sense of well-being, which is a little bit more of a gray line, I think, maybe a little bit less clear. But again, you're still getting into, it'll ultimately be the panel's subjective determination based on the facts and your experiences and understandings of the policy.
All right, let's leave this one.
It seems like no matter what we decide, no matter what we decide, it will still be gray and murky.
I was looking for a lifeline there, but there isn't one. So,
yeah.
I don't know if this is a make it or break it decision.
Nope.
Nope. Let's move on.
Yeah, I mean, this is what we get into when we.
Yeah. I know Representative Palaki could agree to that. So
Yes, let's do
if
it.
everyone else is okay with this, then let's just keep it. So we
Should we ask anyone else to come in to have a discussion?
Nope.
Representative Mouse.
I just scoot out for a quick minute. I get a sports team and just show it.
Okay, and are you good with is or maybe?
I mean, like Taylor said, they're both pretty murky.
Right.
So I think either way would go on.
All right, I'm gonna say is.
Yes, it is.
Okay.
It is.
I'm good with this.
All right.
Okay, good luck.
Thank you.
Great. So the floor here is that workplace harassment does not include petty slights, minor annoyances, or disappointments that an individual may encounter during the individual's time in the State House. So this is the floor that you would apply. And we're just to kind of give structure around that. The only change in that sentence is just there to the individuals, and otherwise it's the language you approved last session. So I'm gonna skip ahead to the examples here where we're deleting work performance and it's just interferes with an individual's work in the examples. And then the next section is where we really start to get some changes. So from procedures and confidentiality, we've changed the heading to reporting and responding to discrimination, since the procedures are in a different document. And then I've got 3 or 4 paragraphs here. The first is identify objectionable conduct. So an individual has a right to identify objectionable conduct and to ask the individual who engaged in it to stop. However, the individual is not required or expected to do so, and there is no requirement or expectation that an individual will identify objectionable conduct to the regulated individual before pursuing other options for resolution. So in other words, affirming people's right to say, stop, I don't like that, but also saying you're not required to do that, particularly in instances where there may be a power differential or other factors at play that make it very difficult for an individual to speak up directly to the harasser. Which brings us to the second paragraph here. The next option is to contact the panel. An individual may contact any member of the panel regarding a regulated individual that the individual believes may have engaged in discrimination. So that gives pretty flexible language there for individuals contacting the panel. And I think the goal here is to make clear that even if you're not sure if it's a violation of the policy, you're welcome to come to the panel to discuss it, because a lot of times people say, well, was that really discrimination? And we'd rather people come and discuss it and ask questions and either get an affirmative yes or a clear no, than that they just let it sit and say nothing and let it continue. The individual may request the panel attempt to resolve the issue informally. An individual who believes that a regulated individual has discriminated against the individual or retaliated against the individual may also file a formal complaint with the panel. The panel has a legal obligation to ensure that the House is a professional working environment free from discrimination, and to take immediate and appropriate action to ensure that conduct that violates this policy does not continue.
Just one quick note, Damien, did you notice the typo on believes?
I did, and I just corrected it. So that's right here.
Yeah, thank you.
That got through editing. So
I'm surprised.
Yep, they are busy right now, so I don't blame them. The next is an individual may contact the individual's supervisor regarding any conduct that the individual believes may be a violation of the policy, regardless of whether the individual engaging in that conduct is a regulated individual. As I'm reading this, I'm remembering that in the sexual harassment policy, we say a person rather than an individual, and I think it avoids some of the potential confusion with the term regulated individual. So I might just suggest that as a global change, because as I'm reading this, it is sounding incredibly repetitive. Does that work? I see one thumbs up from Representative Small. Okay. I'm just going to make a note. Okay. All supervisors have may contact an individual supervisor regarding any conduct that the person believes may be a violation of this policy, regardless of whether the person engaging in that conduct is a regulated individual. This is really important because supervisors have an obligation, regardless of who the alleged perpetrator is, to ensure that discriminatory behavior stops, or to take reasonable steps to try to stop it. So, for example, if a member of the public is contacting a committee assistant in a way that is inappropriate and discriminatory, then the supervisor has an obligation to take steps to ensure that that conduct either stops or, well, that conduct stops. And that could be a variety of things, whether that is speaking to that individual or taking steps with the sergeant at arms and the Capitol Police, depending on the severity of the conduct, to potentially get that individual barred from the State House if it's particularly threatening conduct, for example. That would be an instance. So supervisors have a significant obligation, and this is calling that out to protect their staff from discriminatory behavior. And simply knowing about it and doing nothing is not an option under any circumstances. So, so that's the difference here between the supervisors and legislative human resources and the panel. And then we call out the legal obligation to ensure a working environment free from discrimination and to take immediate and appropriate action to ensure that discriminatory conduct does not continue. And then again, same language with legislative human resources. Person may contact the Office of Legislative Human Resources, and this is brand new because we didn't have an Office of Legislative Human Resources when we did the last draft. And then that they believe may be a violation of this policy, regardless of whether the individual is a regulated individual. The Office of Legislative Human Resources has a legal obligation to ensure that the General Assembly is a professional working environment free from discrimination and to take immediate and appropriate action. Are there questions on those? That's all brand new language, but it essentially repeats what's in the existing policy. Okay.
Yeah,
Yeah.
that looks good.
So I've struck through each of these options as described in greater detail below because that's all in the rules of procedure. And then I've struck through an individual may identify objectionable conduct to a regulated individual. Although an individual may identify objectionable conduct, there's no requirement or expectation to do so because we say that right up above. So where is it? Oh, right here. An individual is not required or expected to do so, and there's no requirement or expectation. So it felt repetitive at that point. And so now the example is an individual is not required to contact a panel member informally before filing a formal written complaint, as the example we give. And so that's basically getting to you can pursue or not pursue one or more of the options. And then the confidentiality, instead of the longer section in the procedures, I've just called out that members of the panel, legislative supervisors, and the Office of Human Resources shall keep confidential any information reported to them pursuant to this policy and any information obtained during an investigation carried out pursuant to this policy, except to the extent necessary to carry out an investigation, enforce the provisions of this policy, and ensure that discriminatory conduct does not continue. And this is important because there are really three different ways that confidentiality may not be able to be kept 100%. The first is in the investigation. You may have to use a name when you're asking questions or provide facts that would make a person able to identify who the parties are. Obviously, in enforcing the policy, you may be bringing in an investigator or other staff to assist you in the investigation and asking questions or in carrying out the formal enforcement process. And then finally, ensuring that discriminatory conduct does not continue. Again, you may not be able to ensure 100% confidentiality if you, for example, have an informal discussion with someone who engaged in discriminatory behavior. So does that make sense to everyone?
Yes.
Great. So the next, and I mentioned this last week, one thing our policy was missing was contact information. So this is just basic contact information, your name, your email address. Since you don't have an office phone number, and I'm not sure whether you would actually want your direct personal phone numbers or your legislative phone numbers in this policy. I see head shaking. So then contact information for the House supervisors, obviously Speaker Krowinski, and then Betsy Ann Rask, the clerk of the House, and then the Office of Legislative Human Resources, both employees there. So it gives people really three different avenues to pursue. And then when we get to staff offices, they would each, in place of the House supervisors here, they would, for example, for my office, it would say Jen Carby, Director and Chief Counsel, Mike O'Grady, Deputy Chief Counsel, and Caitlin Eustick, Director of Legislative Drafting Operations. So those names would be there so that employees in my office would know who to contact. Potential penalties are laid out here. And then we haven't talked about the process for each of these, which varies and is covered in the procedures. So again, if there's clear and convincing evidence, the panel can impose or recommend the following corrective action: counseling or training, removal from a committee, committee leadership, censure, or expulsion. For removal from a committee or committee leadership, that would be a recommendation to the speaker, obviously. Censure or expulsion would require a resolution by the committee that would then get voted on by the entire House. So obviously those are things that you can't do on your own. I think the panel can arguably require an individual to undergo counseling or training. But that may be something that you'd like to have clarified in the House rules, and may want to discuss more with the House clerk as to the procedural ability there. With respect to the House clerk, again, censure or removal would certainly require a resolution of the House. Counseling or training may be something that you can impose, but this may require, again, clarification on your authority under the House rules. And then if they're an employee, all of these would be recommended corrective action to either the speaker or the House clerk, and they would be required to impose that action. The intern staff and volunteers who are basically employed directly by a representative, that language is completely unchanged, except that the sergeant at arms doesn't have to provide contact information anymore because it's in the policy. Training and information, I've struck the language here about members of the panel receiving additional training. It just doesn't need to be in the policy for you to be able to do that. That's something that you could elect to do on your own. And then for other resources here, I've actually used the a person language here instead of an individual. And this is something that you need to consider. First, this first section here is whether you want to ask other House members to serve as facilitators. And the role of the facilitator we've discussed in the past is really someone who understands the options under the policy and is willing to provide sort of advice to their colleagues without their colleagues having to go to the panel. This is something that I've done for my colleagues, and it really is more of a, people can come to you, talk about what they experienced and say, what do I do next? What are my options? And I've done everything in that case from sort of advising people on whether what they experience seems to be a violation of the policy. So we'll look at the policy together. Sometimes I've coached or assisted them in preparing to talk to the individual who might have engaged in the harassment or discrimination. And in other instances, I've sort of helped them determine whether they want to pursue actual panel action. So that's the role of a facilitator. And it's really more of a, so people who you would basically have there as a resource for people without going to the actual panel and initiating sort of the panel's procedures and responsibilities. Does that make sense?
Yeah, I'm thinking in order to proceed and possibly vote on this, I think the process for identifying facilitators would be, in order to ensure a good process, we can't do that right now. And I'm wondering if we could strike the names and contact information for the facilitators is below, and just leave it as the panel is authorized to appoint.
Next year.
So, I mean, that's the other thing is you could strike this for now, and then we can just drop this language back in for next biennium. And you can think about and identify potential facilitators in the interim.
How about if we leave the authorization, but don't put any
Yep.
name, contact information for now?
Yep. Okay.
I think I'm hearing yes from.
Yes.
Okay.
Seems like a great thing to start off with.
Yes.
Okay. Okay, and then the rest of this gets into the other options for resolving it. This language is the same as it was before, except I updated the EEOC's address. Their mailing address changed since we last adopted the policy. And then I added in a little discussion just to be consistent with what's required under the sexual harassment law, just describing what they actually do. So they conduct investigations, facilitate conciliation, and may even pursue litigation as appropriate. Individuals are not required to file a complaint under this policy before contacting or filing a charge with one of these agencies or hiring an attorney to pursue a civil action. Just making really clear that people don't have to do the internal process, particularly because in the case of an employee who feels they've been discriminated against by a member, they may not feel comfortable pursuing a complaint with a panel comprised of House members. And that's nothing against the members of the panel. It's just that people who don't know you may not trust that it's a fair process, just because of the perception that House members judging their colleagues, may or may not have the employee's best interests at heart. So that's it. We made it through. So you guys are faster than the sexual harassment prevention panel. So that's good.
Okay. Take a
So
vote.
hopefully, and at this point, the changes you've called for here are pretty quick. And then we can speed this up given the time left in the session. That's definitely an option. So I would leave it up to you, and you can let me know if you want to meet quicker than 2 weeks from now. Or we could aim for 2 weeks from now and then have another meeting shortly thereafter to vote.
So I was thinking of asking if we could meet at 8 instead of 8:30 on the 29th. Is that a possibility for you, Damien, you, Mike, all of us in the room?
It would be hard for me to do an 8 o'clock meeting since I can't drop my daughter off at school until 8. So,
okay.
But I can join you from my office as early as 8:15. If that works for the panel, that would help speed things up a bit. And I can also do lunch meetings if there's a lunchtime that works for everyone. I know that's not ideal, but.
Mike, how about, does 8:15 work? And if it's okay if it doesn't, 8:15 is fine.
8:05 is something. I get here between 8 and 8.
Okay. Let's set it for 8:15 on the 29th. Damien, do you think we need to go through the procedures before we vote on what we just did today?
No, we could vote the policy out and do the procedures.
I was thinking of taking a vote right now on the policy and getting that done.
It might make sense to wait for the whole panel to be present on the policy and to have a clean copy. So, I mean, you do have a quorum, but just saying, you know, if it's going to be the panel's policy, it might make sense just to give everyone a chance to vote on it and to see a clean copy.
So how about you, we'll wait for you to send us a clean copy. And in the meantime, we can find, I can imagine it's only going to take 15 minutes to hold a vote. And in the meantime, we can work with all of us and legislative operations to find a time where we can have that 15 minutes to vote on the policy. And then we only have to focus on the procedure on the 29th.
Yeah, I can make the changes today and then get them out to you early next week. So I know drafting operations is slammed with amendments to all of the last minute bills going back and forth, but they should be able to get it out by early next week.
Okay.
And then we can just meet next week for a few minutes.
And we can find 15 minutes.
Okay.
Is here good? This room?
Yeah, it's perfect. We're all on
Okay.
the so it works great. All right, thank you so much, Damien. Thank you.